Welcome to An Ounce of Prevention, the podcast. At our recent associates, we believe that an ounce of prevention is worth a pound of cure. Our daily commitment lies in informing our clients about legal risks without hindering their business objectives. As we like to say, we're in the business of building companies and helping executives sleep at night. So stay tuned. Maybe you'll learn something that'll help your business grow and thrive.
Welcome to An Ounce of Prevention, where we believe an ounce of prevention is worth a pound of cure. I'm your guest host, Miranda Caballero. As 2025 comes to a close, I thought it would be a good time to look at some of the cases that are shaping Texas business law. Specifically, we're talking about early decisions coming out of the brand new Texas business courts. These courts are designed to handle complex cases more efficiently with judges who specialize in business law. Here's a little background. In 2023, the Texas legislature passed House Bill 19, creating the Texas business courts. There are supposed to be 11 divisions across the state, but for right now, only 5 are active. Those are in Austin, Dallas, Houston, Fort Worth, and San Antonio. They officially started hearing cases this year, which means these early opinions are setting the stage for how complex business litigation will be handled in Texas for years to come. So let's dive into our first case, Kassam versus Dosani, out of the 11th Division in Houston. This case is about whether multiple claims should be tried together or separately. Here's the setup. The defendants were facing 6 claims from the plaintiffs. These claims included breach of contract, breach of fiduciary duty, access to books and records, attorney's fees, and requests for receiverships and injunctions. All of these claims involved alleged mismanagement of 3 LLCs: ZZLS, MSW23, and Valley Trading Company. The defendants argued that the claims involved different LLCs and the plaintiffs aren't members of all 3. So therefore, there should be 3 separate trials. But the court disagreed. They found that the claims were interconnected with overlapping witnesses and evidence. Trying the cases together would save time, lower cost, and make the whole process more efficient. So why does this matter? Although still early in the court's existence, Kassam versus Dosani demonstrates that the business courts are fulfilling the legislature's promise of increased efficiency while handling complex, multi-entity business disputes, which could save litigants time and money and influence how we structure litigation strategies. Moving on to our next case, Invincible Inc. versus RBH SP One LLC, from the 8th Division in Fort Worth. The case concerns 3 issues: breach of contract, derivative liability, also known as piercing the corporate veil, and fraud arising from an acquisition gone wrong. Here's the story. In 2023, Robert Burns, through his companies, tried to acquire a 49% stake in Invincible, an online eyewear company. Invincible claims Burns misrepresented his financial position, so when the initial closing date passed without payment, even after 5-month extension, they terminated the deal and filed suit. Invincible's first claim, breach of contract, was against Robert Burns personally, alleging that Burns agreed to transfer assets into the 2 entities to perform the acquisition agreement and failed to do so. The court determined that the breach of contract claim against Burns himself failed because the only parties to the acquisition agreement were the LLCs. Burns was not a signatory individually. Invincible's second claim, the veil-piercing theory, alleges that the LLCs were undercapitalized and insolvent, ignored corporate formalities, and served as a facade for the Burns family business. The court determined Invincible's veil-piercing claim failed under Texas law. In Texas, members and managers of an LLC are generally shielded from personal liability for the company's debts and obligations. Invincible's veil-piercing claim stemmed from Delaware veil-piercing principles, which can include inadequate capital, failure to observe corporate formalities, and insolvency. However, it is not settled that Texas law even allows veil-piercing for LLCs. Additionally, under the Texas Business Organizations Code, a member or manager of an LLC may be held liable for a matter arising from a contractual obligation of an LLC, only if that person perpetrated an actual fraud, primarily for the direct personal benefit of the manager or member. Lincible did not allege that any of the Burns defendants committed fraud for their own personal benefit. The claim failed because Lincible's Delaware-style veil-piercing theory could not stand under Texas law. Lincible's third claim, fraud, stemmed from allegations that Burns represented that he and his two entities had a net worth exceeding the price of the agreement. Despite knowing his net worth claim was false, Burns still instructed an employee to carry out the agreement. Finally, the court determined the fraud claim against Burns himself was adequately pleaded. Lincible showed that Burns made a false representation about the capital amount and knew it was false. Since Burns' CFO pointed out the false representation and Lincible entered into the agreement based on Burns' representations, which prevented it from seeking other deals. So why does this matter? Lincible versus RBH SPE One is influential because it is one of the earliest Texas business court decisions to draw a firm line between Texas and Delaware corporate law, particularly regarding veil piercing. By refusing to import Delaware-style veil piercing principles and instead analyzing the Texas Business Organizations Code, the court signaled that Texas will not simply mirror Delaware. This distinction will have real consequences for deals, lawyers, and for anyone structuring LLC-based transactions with choice of law clauses in Texas. Finally, we have Riverside Strategic Cap Fund 1 LP versus CLG Investments LLC from the First Division in Dallas. This one is really about timing. Riverside invested millions in True Health Group, a medical diagnostics company, even though they were on notice about alleged fraudulent practices. Between 2016 and 2020, True Health faced multiple investigations, Medicare suspensions, and ultimately went bankrupt. Riverside didn't sue for fraud until 2025. The court ruled the fraud claim was time-barred. Under Texas law, the statute of limitations for fraud is 4 years, and the clock starts ticking when a reasonably prudent person has enough notice to investigate. Riverside had notice of these allegations more than 4 years before filing, so their case came too late. So what's the big takeaway from today's cases? These early Texas business court decisions are already shaping the way complex business disputes are handled. They're setting benchmarks for efficiency, corporate governance, and litigation strategy. Whether it's deciding how claims are joined, clarifying the limits of veil piercing, or reminding us about the importance of making timely claims, these cases are laying the foundation for the future of Texas business law. I want to give a quick shout out to Francis Warden, our law clerk in our Denver office, for helping put together this episode. Thanks for tuning in to An Ounce of Prevention, and happy holidays from the RRNA team.
The information and material in this episode is general information about our practice and firm and is for educational and informational purposes only. This information does not offer specific legal advice, and the use of this information does not create an attorney-client relationship with RRNA or any of its attorneys. The information in this episode, or any episode of An Ounce of Prevention, should not be considered legal advice, and persons should not act upon this information without first engaging professional legal counsel.
Thank you for listening to An Ounce of Prevention, presented by R. Reese & Associates. If you found this episode informative, subscribe to, rate, and review our podcast on Spotify, Apple Podcasts, YouTube, or wherever you listen to stay up to date with future episodes, case law updates, and breaking news. If you have any questions or are interested in learning what RRNA's outsourced legal department can do for your company, reach out to us at podcast@rreeselaw.com. That's podcast@rreeselaw.com. Follow us on LinkedIn or call 832-831-2289.